Welcome to the Melling Law YouTube channel. Today we are going to talk about agents. No, not that kind of agent. I'm talking about a power of attorney. Yes, I agree Matt Murdock, also known as Daredevil, could be considered a powerful attorney, but I said power of attorney. Let's talk in terms of a financial agent. You may want to appoint a financial agent as an estate planning tool. Your agent can be a spouse, business partner, friend, or anyone you choose. Whether you need to have someone with authority to manage your financial accounts due to convenience, extended trips, or, in case of serious illness, these documents are flexible and can be tailored to your needs. The best thing about having a financial agent is that in many ways it forces you to think about your estate plan on a regular basis and helps you be more planning-oriented. On top of all of those benefits, Utah Power of Attorney documents have built-in legal protections regarding appropriate transactions and agent duties. One of the biggest drawbacks of having a financial agent is the fact that you need to trust the agent to handle your finances. If you don't trust anyone to be your agent, you shouldn't appoint anyone as your agent. Another drawback is internal banking regulations that might make it hard to use a financial agent if you do not give your bank a copy of the power of attorney document within a certain period of time from the time you sign the document. Finally, some state laws do not recognize out-of-state power of attorney documents, so if you have property in multiple states, you will definitely want to speak with an attorney about your agent options in other states. Now, I'm sure you've heard of a durable power of attorney. Durable doesn't mean that the document is recorded on stone tablets or anything like that. Rather, it refers to the document's effect after you've lost the capacity to contract. This is most common in cases of brain injuries, dementia, Alzheimer's disease, or persistent states of unconsciousness. In those situations, you lack the legal capacity to enter into contracts, so it helps to have someone standing by to pay your rent, buy and sell assets, and manage your business affairs if you're ever in one of those circumstances. The caveat here, however, is that you cannot sign a power of attorney without the legal capacity to sign it, so you need to sign it before an accident or illness, not after. Finally, just like a non-durable power of attorney, durable powers of attorney do not extend after death, so you don't need to worry about your agent taking your assets for himself after he dies and running off with your inheritance, which reminds me of a common question. What if my agent runs away with my money? Well, there's a simple answer. That would obviously be a criminal act and they would go to jail, assuming the police can outrun the yacht that the agent bought with stolen funds. The Utah legislature was aware of agent concerns, so there are some built-in protections for people signing power of attorney documents. First, the Utah Code states that there are some transactions that the agent simply cannot perform without express authorization in the power of attorney document. These transactions include pretty much anything relating to trust accounts, making gifts with your money, or changing your beneficiary designations on life insurance or retirement accounts. Further, there are several types of transactions which are avoidable, meaning you or a family member can contest the transaction, and a court would treat the transaction as if it never happened, unless the court decides to approve the transaction. Those transactions include anything that would benefit the agent's spouse, the agent's attorney, or any other entity where the agent has a significant conflict of interest. There are a few other things to keep in mind with power of attorney documents. First, you can make them effective immediately or upon disability. I usually suggest that people make them effective immediately, since the agent would otherwise have to get a doctor's note saying that you were disabled before he could do anything. That might take a week or even longer. Meanwhile, your bills might go delinquent. Second, you have the option to nominate successor agents in case the first agent is unable or unwilling to serve as such. Third, you can designate people to serve as co-agents. It requires both agents to sign off on anything that one agent does on your behalf. This usually ends in disaster, but it can be a good idea in a very limited set of circumstances. Fourth, if a court decides that you are no longer fit to manage your own affairs, you may have a conservator appointed over you. The court may in fact appoint your agent as your conservator, but if not, the agent will need to report to the conservator. Then the conservator would also have authority to remove your agent at any time. Fifth, Utah state law allows you to appoint a healthcare decision-making agent in addition to a financial agent. Many people prefer to nominate the same person for each role, but you don't have to. Either way, healthcare agents are a vital part of any estate plan, which is why I created a video explaining Utah's standard form for nominating a healthcare agent. Beware, it's a real snoozer, so before you watch it, go grab a cola and maybe speed it up to 1.5 times the regular speed. And that's about everything you need to know about the power of attorney document in Utah. If you have any more questions about planning for your specific situation, you should discuss them with an estate planning attorney. At Melling Law, our initial consultation is free, so we can take the time to recommend the best services for you. You can reach us anytime at 435-572-0807 or by email at office@mellinglaw.com. Please subscribe for more updates on estate planning, probate, and asset protection in Utah.